Well, good afternoon, everyone, and welcome to today's session.
Hi, I'm Leighton Smith, and this is Paula Noble. We are in the real estate team here in the Brisbane office of Clayton Hughes. And thank you for joining us. These are certainly interesting times that we're living in and through. Obviously, the way that we live and the way that we work has all changed recently. This is obvious because we're coming to you via the internet rather than in person. This is our first virtual seminar, and so we hope that you really enjoy the format.
We hope that you don't miss the CU catering too much, but there's unfortunately not a lot we can do about that.
And we'll also point out as we get into it that there's a question and answer function down in the bottom right-hand corner of your screen. So we encourage you to send through any questions that you might have as they arise. We've got a team behind the scenes that are moderating the questions, and we'll send them through to us. And so we'll try to answer them as they come through. We've also left some time at the end of the presentation to address them. But if we can't get to them today, we will certainly come back to you after the presentation. So please also note that this session today is being recorded and will be circulated after the event as well. Before we commence, we'd like to acknowledge the traditional owners of the custodians of the land on which we are currently on, and we would like to pay our respects to their elders past, present and emerging. So even though it seems like we've randomly chosen a selection of legal words for today's topic, there's actually a reason for it. Tenancy and occupation of premises requires documentation. It's always a fast-moving environment, and there's a lot of pro forma documents that have been created over the years, flying around between the landlord and the tenant and the agent and the lawyers, of course. The parties always prefer, obviously, to spend less money at the outset of a matter than more. People aren't usually too excited about paying their lawyers stacks and stacks of money for more words on paper. And so for this reason, it's mostly okay during good economic times that these template or pro forma documents are used. However, during bad economic times, like at present, documentation and the words on that paper actually becomes really important. And so there's an opportunity now for property owners and occupiers of property to focus on getting the documentation right moving into the future. And so here's what we're going to cover today. Paula will work through leases and licenses generally, talking about what each of them are and giving some tips in relation to when to use a lease or a license and what circumstances either one of those might be preferred. And then I'll talk about deeds and agreements, specifically in relation to property transactions and mostly leasing and licensing. But the principles that I'll talk through apply generally in relation to deeds and agreements as well. I'll also explain when a deed or an agreement might be preferred and what can happen if you get it wrong. And then Paula will close out the seminar with an update on execution during these COVID times. So here's Paula.
Thanks, Leighton. So just to elaborate on the why in relation to looking at leases and license, the biggest confusion that we tend to see is that people do use leases and licenses interchangeably and perhaps sometimes not quite in the right context. So there are some impacts and effects from getting it wrong, which we will go on and discuss as we go. But an important thing to note is that most of the time, whether you use a lease or a license won't really impact too much, provided that the contractual document actually does what you want it to do. As Leighton said, it's during the difficult times or during challenging circumstances or when one party wants out that these kind of issues get brought up day to day. So in the current economic climate with COVID on the scenes, we're probably going to start to see an increase in people looking at their occupancy documents to work out if they're a lease or a licence. And the main driver for that is the mandatory code of conduct that's being enacted through all of the states. And that code of conduct basically provides tenants with some form of rent relief if they're an affected lease. So I think at the moment there could be a few people trying to work out if their licenses are actually leases in order to get the benefit of some rent relief from the landlord there. So we kind of thought that it would be a pretty good time to go and do a bit of a refresher and work out what the differences between leases and licenses are. An important thing to keep in mind is that a court's not going to care what you call a document. So there are lots of instances where a document is quite obviously being drafted to be a licence, but when you look at the factual matrix, it's been a lease. So the court won't shy away from calling it a lease, even though it may be named a licence. So it's time to look into what is a lease. So a lease is a contract that grants to the tenant an estate or an interest in land for a fixed term. So that kind of sounds like a licence as well, is granting rights of use for a fixed term. What the courts have found is that exclusive right of occupation or exclusive possession is an essential part of the lease. So an interest in land is a right to exclude all others. So this is the most important aspect of distinguishing between a lease and a licence. So this is very much a factually based element. So you've got to look at the nature of your premises and the rights that are granted under the document. So if you've got an area that you can shut the door, you can lock the gate, you can control who comes in and who leaves, and you can exclude the landlord in certain circumstances, then it's going to be aligned with the fact that you actually have a lease. So exclusive possession and the right to keep others out will be a leasehold interest. And as I said, it is completely factually based. So it will determine whether there's doors on the shop, locks on the gates. You'll need to have a look at whether it's in a public accessible area. So those kind of factual matrix will all feed into whether exclusive rights of occupation are given. You also need to look at the document drafting to see what rights the landlord might have and what they've reserved for themselves. So if they've got rights to come in and use the premises at any time, then it's not going to be a lease. So if you want to understand, if you ask us to help you with your leasing or licensing, why we might ask you a lot of questions, this is it. We're trying to establish the factual matrix of what you're trying to achieve with your documentation. So we will ask you some probing questions about the way you use it, about the way it looks, about the way it feels, the fencing, lockability, other people's rights of access. So they're all factual requirements on working out if you've got a lease or a licence. So there are some benefits that a lease offers that a licence does not. And this is quite often why people would like documents characterised as a lease versus a licence. So the biggest drawcard for leases is that they can be registered. And they actually must be registered if their term exceeds 3 years. And the benefit of registration is that the tenant has indefeasibility of their interest. So for a lease less than 3 years, by law, a tenant is entitled to indefeasibility. For a lease over 3 years, you must register the lease to have that benefit. And for those of you who aren't quite sure, haven't heard the word indefeasible at home, what that means is basically indefeasibility means that your lease is not subject to challenge. It's recognisable by the whole world. So people can't try and disclaim your interest at a later stage. The another benefit of leases is because they are registered on title, they're quite often seen as more bankable. And by that, I mean that you are actually capable of granting a mortgage over a lease interest. So this makes it quite attractive for the financing world. If you've got lending for large infrastructure placed on a leased area, a bank's going to more than likely wish to secure that lending via a mortgage that's registered on the title. In relation to the next benefit, leases are generally assignable, which means as a tenant you could go and assign that in relation to your interest in the lease. So just be a little careful of that. That does come back to contractual drafting to make sure that you've checked the boxes in the lease as to whether your lease can be assigned and what process. But generally you'll find as a rule of thumb that leases can be assigned. The other benefit is leases automatically run with the land. So what I mean by that is where the landlord sells the land, the leases will automatically be assigned to the new owner of the property without any further documentation required. In practice, we do tend to still get deeds of covenant from the incoming owner of the land, just to make sure that those personal obligations that might be in the lease are also assigned. Because the rule of running with the land is that only those covenants that touch and concern the land will actually run with the land. So rule of thumb, we probably do generally suggest that you do get deeds, but it is not critical. The other biggest benefit of a lease is that there are certain protections from law in relation to termination. So you've got the Property Law Act requiring a landlord to issue a notice to remedy breach and give the tenant a reasonable time to remedy that breach before the landlord would have a termination right. Similarly, the tenant also has rights from forfeiture to stop a termination happening by applying to court. Some other laws that may impact on leases and provide tenants and sometimes landlords with protection are the Retail Shop Leases Act and also the COVID leasing regulations. So leases do also have a few limitations. They tend to be less flexible when you're talking about area changes. So it is possible to make a leased area smaller by a partial surrender. It's equally possible to make a leased area larger, but you would do that by granting a second lease over the extra additional area. Licenses are a lot more flexible in that, which we will talk about. The other limitations of leases is that they actually cost more money. So if you are looking at a registered lease, you need survey costs because the lease plan needs to be in land titles format. You've got land titles, registration fees, and also the documentation that gets prepared is more comprehensive and more formal. So you're going to see a higher cost in preparation costs for a lease. That's not to say I haven't seen some pretty complicated license agreements over the time that can be very comprehensive and costly. So overall, a lease is probably a superior interest to hold, but all forms of tenure have got a right time and a right place. So let's look at a license now to work out what the differences are. Because on the face of it, they both give rights to use land and they can have both a very similar set of obligations on both parties. So a licence is a contractual right granted by the licensor to use the land. not an interest in the land. And the big issue is a licence doesn't give exclusive rights of occupation and use. So it may be that it's interrupted use by the landlord, or it's use in common with other people, or that the very nature of the area, the licensed area, can't be locked up, can't have any way of excluding others. So it's quite very much a factual situation, and also what the contractual suite of rights are for other people to use. So moving on, the benefits of the licence. So the benefits of the licence and the limitations of the licence seem to be the flip side of the lease arguments there. So licences are extremely flexible. If you can dream it and you can draft it, you can have it in relation to a licence. So we've seen that licences can often allow areas to change over time. So you can see that some very common examples would be a car parking licence. So you might have a car parking licence, the right to park one car within a whole big space. So it might be that you park your car in space 6 on day 1 and you park your car in space 22 on day 2. So it allows that flexibility for the areas to change. You're not actually getting a hold on a particular point in a land, of land. The other common agreement that we see is a rolling adjustment licence, where you might have a right to graze 100 head of cattle, and that area that you can graze in changes over time. So licences can give you that flexibility to change that. The benefits of licence is they are actually personal in nature, so you can actually do a deal with one particular person, knowing that that deal is between the two of you, and with the right drafting, doesn't need to be, it can't be assigned or so forth. But it's one of those things that you can actually draft it the way you want it. So if you want it to have some flexibility, you can put in a process map for ensuring that someone else has those similar rights. Some of the limitations of licence, so it's not registered. So with that registration comes all of the other issues. So it's not going to run with the land. So if you do want subsequent owners of the land to have the benefit of the licence, or the contractual obligation to maintain your licence, you need to rely on your contract rights. So you'll need to make sure that if the licensor sells the land, that they have a contractual right to make sure that the incoming owner honours the licence agreement. Another issue with that is it's also seen as being less bankable. So licences certainly can be covered by general security agreements. But when you're looking at significant financing for infrastructure, for example, a licence may not actually meet the bank's requirements for security. And it's because of the fact that it isn't recognisable by the whole world, and it isn't registered. So the other thing is the legislation protections just don't apply to licences generally. The legislation protections in the Property Law Act, in the Retail Shop Leases Act, in COVID leasing variations apply quite strictly to leases. So, for instance, the protection of not being able to terminate without giving notice of breach and a reasonable time to remedy that breach, they're all legislation protections that wouldn't apply to a licence. None of these things are fatal, because we can get around that in your contract drafting to make sure the licence provides for that notice requirement and a reasonable time to remedy the breach. It just doesn't apply at law. Licences are not always assignable, but as I said before, you can actually work around to have a process map in your licence to make sure that other people can gain the benefit of that licence. So they're the main distinctions between leases and licenses. And we are going to run through just a quick case example just to drive home the difference. And this case example kind of very much highlights it does not matter what you call your document. So we're just going to look at the case of Baker Hughes Australia and the Darwin Port Corporation. So in that case, Baker Hughes, the plaintiff, supplied services to offshore oil and gas industries from the East Wharf in Darwin. In order to carry out its business, it actually obtained the rights to use 6 parcels of land from the Darwin Port Corporation. And we're looking at, this case looks at one of those sites. So in 2002, Baker Hughes constructed and established and occupied a liquid mud plant. So the liquid mud plant was exclusively used by Baker Hughes, and it was used to mix and store drilling and completion fluids and chemicals required by Baker Hughes's customers who were involved in offshore oil and gas operations. Now, Baker Hughes spent a considerable amount on building the mud plant infrastructure at the cost of $4.3 million. Now, at the time of construction in 2002, there was actually no written agreement to occupy in place. That later came along in 2007, where the parties agreed and signed up to a document that was called a license to occupy. So looking at this license to occupy, it contained a pretty normal standard clause that we do see in licenses, and it's not dissimilar to any of our licenses. So clause 2 stated that the grant of the license creates contractual rights only and does not create or confer on the licensee any proprietary right, tenancy, or other estate or interest over it or in the land or the licensed premises. So it's quite clear in that statement that they were intending it to have rights of license and no interest in the land. So the court was asked to decide, was this a license to occupy? Was this license to occupy a lease or a license? So the Supreme Court found that even though it was called a license to occupy, it was in fact a lease. So there are a couple of rationale that they gave for coming to that conclusion. Was the license to occupy acknowledged that Baker Hughes had actually made a significant investment in the mud plant on the land. So they'd spent $4.3 million. The main driving point was the mud plant was used exclusively by the plaintiff in its business operations. So nobody else had the rights to use, and the usual lease conditions were contained in the licence, allowing the plaintiff to exclude the landlord from the premises except in certain situations. The other thing the court looked at is there were a lot of conditions in the document that looked like a lease, and one particular one that they mentioned in their decision was the Darwin Port's right of re-entry was only on breach of covenants, just like a lease. So in that case, the license to occupy, despite being called a license, was actually a lease. So it's cases like these that demonstrate that when things do go south, there is scope in documents to review to work out what the actual practical intention of the document were. Now, just to finalise and round out that leasing versus licensing discussion, I thought I'd just mention a few common examples that we see of each category. So leases is quite easy. The retail shops that we see, the commercial office that we're sitting in right now, whole farmlands, a whole of building, industrial building, those kind of things are pretty normal examples of what you would see lease. License, there can be varied. I think I've already spoken about adjustment licenses, and car park licenses are fairly common. Entertainment licenses, and what I mean by that is those skill tester machines and those rides that my kids harass me about every time I go to a shopping centre. Those kind of things, because they are publicly accessible and don't have exclusive possession, they're generally by way of licence. Signage licence is really another good example of a properly used licence. You can also have access licenses, and you might be careful about access licenses in the way you use them, because quite often an easement might be a better form of agreement, depending on what you're using it for and how important security of tenure is. So it really comes down to a factual basis as to, whether you should be using a lease or whether you should be using a licence. And it also comes down to some commercial decision making as well. So we often do see that licences do get used in the place of leases, which is fine, provided that they're drafted in a way that does what you need it to do, and provided that the parties are cognisant of the risk that there is potential for a licence to be found to be a lease. And the things that you need to be a little bit careful of is making sure that you're not terminating, if it is a licence that probably should be in a lease format, that you're actually complying with the laws in relation to termination. If it's a retail shop licence, that should be a lease, that you're giving the disclosure statements and you're complying with the Retail Shop Leases Act. So provided that you're aware of those risks and the outcomes, and provided that you understand that there is potential that that licenses could become a lease at a later stage in the event when things go south in the relationship. As long as you take on board those risks, commercially you might be okay with having a licence document. So that's it on leases and licences, and we'll move on now. I do have a couple of questions, but we'll run through them at the end. So Leighton's now going to take that and talk through deeds and agreements.
Thank you, Paula. So after the parties have made a decision as to whether to enter into a lease or a licence that suits their needs, the next important step is to consider whether that document should be a deed or an agreement. These are some common examples of documents that you see if you're in the property field, or if you're a tenant or a landlord. You see them most days of the week. There's leases, obviously. Leases can be an agreement or a deed. It's common to see both. There's agreements for lease, deeds of consent to assignment and subletting, fit out and incentive deeds, deeds of variation, guarantees, deeds of surrender. These are all documents and all words that we throw around all day, every day. Usually when these documents are prepared or negotiated, they're based on either the landlord's pro forma or the tenant's pro forma, depending on how much negotiating power the tenant has, or a law firm's pro forma document or template document. So the message for today that we hope you take away is that we think there should be more thought that goes into what form of document you take on. And obviously that depends on each matter and its own circumstances, so it needs to be assessed on a case-by-case basis. Is it appropriate in these circumstances, for example, to enter into a fit-out and incentive deed, or should it be a fit-out and incentive agreement? And I'll explain the differences between the two. Starting from agreements. An agreement if you think of a normal form of contract where there's, say, a buyer and a seller, a supplier and a recipient, or a landlord and a tenant, there are three basic elements to establish an agreement, and that is offer, acceptance, and consideration. There are more, obviously, than that, but for the purpose of today, they're the three basic ones. One party has to make an offer, another party has to accept that offer, and there has to be consideration that flows between the two, and not consideration in the usual sense. It's consideration in the legal sense, which if you think of money mainly, it can be money or goods or services, but it's usually money. So the rent paid under a lease is consideration paid by the tenant to the landlord. An agreement requires at least two parties. Like I said, there's got to be a meeting of the minds. In order to demonstrate the ease of use of an agreement when compared to a deed, I've listed a couple of things here. There's no risk in executing electronic counterparts of an agreement. So you can apply an e-signature, or you can sign a bit of paper and scan it and email it or fax it, provided that the agreement itself allows for that. You can also exchange letters or emails, or you can do a further agreement if your agreement allows those things in order to vary the original agreement that you made. So agreements are much more day-to-day user-friendly, I think, than deeds, because they've got those benefits. Normally no witness is required as well. Well, it's common for a witness to sign their name next to an execution panel or something like that, just so that for down the track, if they need to prove that it was the person who signed it. But there's no actual requirement for an agreement to be witnessed. And the last point there, most importantly, is that there's a limitation period of 6 years. So if there's a breach of an agreement, a breach of contract, the period after that breach, during which the aggrieved party can commence proceedings, is usually 6 years in Queensland, and that's enforced by legislation.
Probably the most perfect example of the right place for an agreement in our property world is a contract of sale. So when you're contracting to buy your house, for instance, the fact that you can scan and email that over, the fact that it doesn't need to be witnessed, the fact that you can extend the settlement date by exchange of letters is a perfect example of the benefits of agreements. It makes that adaptable regime and that ability to get things signed quickly, easily, and also to vary it. So it's a perfect example of an agreement at play.
In contrast to that, a deed is very different. And if you have a look at the case note down the bottom, that Vincent and Primo Enterprises, the court said a deed's very different from a contract. And then I'm talking about a contract or an agreement in this case. On a contract for the sale of land, the contract is not binding on the parties until they have exchanged their parts. But with a deed, it's different. A deed's binding on the maker of it, even though the parts haven't been exchanged yet, as long as it's been signed, sealed, and delivered. So a deed can bind only one party to that transaction, provided they've met the formal requirements of execution and exchange. And I'll talk about them in a second. But there are two other important points. When I was talking about agreements, I said there's offer, acceptance, and consideration. Consideration is not required for a deed. So there doesn't have to be an obligation for the parties to pay any money to the other or provide goods or services. A deed can stand on its own merits without that requirement. Lastly, deeds have got a limitation period of 12 years, so double in Queensland. In other states of Australia, it's 15 years, so it's a much longer time, after which breach the other party can commence proceedings if they need to. I was talking about the formal requirements of a deed. I'll just point out, this is outside of COVID in the normal course. And Paul will talk about what's happened now that COVID's around. But in the old times, in common law, a deed had to be signed on parchment, vellum, or paper. And then it had to be sealed. So someone would apply their own personal wax seal to this thing and deliver a physical copy of the document. And only once those things had happened, the deed had been signed, sealed, and delivered, then it was binding. It was, in a way, it was easier back then because it was obvious once a party was bound by the deed. But now, of course, things are more confusing in this modern world. So the Property Law Act has not got rid of those common law requirements, but varied them so that nowadays you're only required to sign. Normal paper is fine. I've said there you don't have to find parchment or vellum or whatever that is. But a wet ink signature is still required. The deed also has to be expressed to be a deed. So that shows the party's intention that what they're doing is not just signing an agreement, they're actually signing a deed. And that's evidenced by things within the document itself, so the words used and the content and the effect and all of that, obviously. In execution panels, it's not uncommon in a deed for the words "this deed" to be used, or this deed is executed as a deed, or this is signed, sealed, and delivered by the parties. Those sorts of things. Deeds, unlike agreements, also have to be witnessed. So an individual or an attorney, when they're signing a deed, has to do it in the presence of a witness. A company doesn't have to, but it's got different requirements because it can sign under the Corporations Act. But for today's purposes, deeds have to be witnessed. And also, deeds still have to be delivered. Not in the same sense as in the old days, but there has to be an obvious intention in the deed to say that when a party signs this document and sends a copy to the other side, they're intending to be bound immediately upon that delivery. And as you might expect, there are some serious consequences if you get it wrong. I'll quickly mention this top point. Sometimes parties hope to enter into a deed or be bound by a deed or whatever, but if they don't do it right and if they don't meet those formalities, then that document can fail as a deed but still be binding on the parties as an agreement. And that's confusing conceptually, but what it means is you don't get the benefits of that document being a deed, for example, the extended limitation period, but provided it meets all of the other requirements of being an agreement, the document can still be treated as legally binding as an agreement. The most obvious risk also in that is that deeds sometimes don't have consideration, like I talked about. So if there's no consideration that passes in that document, it won't even continue as an agreement. But I just note that for completeness at the top. More problematic than that is that you can have an unenforceable or non-binding document, and that's problematic. You can also, conversely, have an unintentionally binding arrangement. In this case example, a developer, 400 George Street, was trying to find a tenant, and they found a potential tenant in BG International. And parties, as is common, executed an agreement for lease. So the developer could go and rely on that agreement for lease and construct the building, and then they'd have a tenant when it was done. The execution clause in that particular agreement for lease stated that it was executed as a deed, and the signatory signed, sealed, and delivered the document. So that language that I was talking about before, one indicator that the document was trying to be a deed. The problem was this was an accident, and the people who prepared the document, so they said in court, unintentionally used that language. It should have been an agreement. The document was called an agreement for lease, obviously. It referred to itself as an agreement. So there was this complication that the language was inconsistent, so it was hard to ascertain what the parties' intentions were. Importantly, after the tenant, proposed tenant, I should say, executed and returned the agreement for lease, but before they paid any consideration under it, and importantly, before the landlord parties had all confirmed that they'd countersigned it, they withdrew their offer to lease and argued that they weren't bound by that agreement for lease. They said that the agreement for lease is an agreement, clearly, and no valuable consideration had passed between the parties. And in any event, there was a mutual intention that was set out in the heads of agreement and replicated in other documents that the parties would only be bound at the time they had mutually agreed legal documents. So the court was faced with a problem, and they had to determine whether the agreement for lease was an agreement or a deed, because if it was an agreement, then the tenant could probably get out of it. If it was a deed, the tenant had more obstacles, because upon delivery were they bound immediately by that deed. At first instance, probably surprisingly, the Supreme Court said that there are many factors to consider in ascertaining whether the document was a deed. There's up to 10 they listed. One of those factors is that the document itself said it was executed as a deed. And on that basis, the Supreme Court held that the agreement for lease was actually an agreement and that the tenant was free to go. However, that was very quickly appealed by the developer. And the Court of Appeal overturned that decision and said, no, it's not an agreement, it's a deed. Surprisingly though, and very, very importantly, they focused in on that one execution panel that was apparently accidentally put in there, that the document was executed as a deed and signed, sealed and delivered. The Court of Appeal said that was unequivocally express intention for the document to be a deed. And so the determination to overturn the ruling at first instance was based pretty much on that passage and that language. So the problem was, however, in this particular case, just to round it out, there was no intention to actually be bound by the agreement until the future condition that I mentioned, the parties being having mutually agreed legal documents, was satisfied. So the tenant got away with it on a technicality, but the important takeaway is the language that you use in the document, especially in the execution panel, is very, very important.
So for the lawyers in the room, be super careful about your execution clause that you use. So if you are wanting it to be an agreement, please do not use executed as a deed or the words signed, sealed and delivered. Because as this Court of Appeal case found, that by itself was enough to push it over the line to be a deed. BG were pretty lucky in the fact that the actual terminology meant that it wasn't delivered at this time, because there was no mutually agreed legally binding document.
And so quickly closing this out, when you're asking yourself whether you want this to be a deed or an agreement, you need to consider firstly whether limitation periods are important to you. Remember that it will also apply to the other side. So one party can't just get the benefit of a 12-year limitation period and the other's stuck to a 6. It works both ways, of course, but that could be mutually important. Also, corporate restrictions might place limitations on the execution of deeds that bind a company. So an example is a power of attorney that's executed by a company, giving the attorney powers to sign certain documents. It's important to make sure that the power of attorney document itself authorises the attorney to sign, seal and deliver deeds on behalf of the company. The number of parties and the imposition of obligations is also important to consider, because if there are multiple parties, at least 2, and you want both of those parties to be bound only upon payment of a deposit or a satisfaction of a condition or something like that, that would suit an agreement style more. Alternatively, if you want one party to be bound immediately upon delivery of the document, a deed would be more appropriate. If there are difficulties in proving consideration, then a deed is the obvious answer to fix that problem. Examples of this are guarantees and indemnities. There's language used in guarantees and indemnities to say that in consideration of the lender perhaps agreeing to offer money to the borrower, then the guarantor guarantees these certain obligations and etc. That's to try and get around this no consideration issue. But if it's a deed of guarantee, then consideration doesn't have to be a problem. Likewise with deeds of consent and similar, where a landlord's consenting to an assignment or a sublease. If execution in counterparts or electronically is important, most days of the week and when COVID isn't happening, that would require an agreement. And if you'd like to vary this document easily moving into the future, if you don't want to have to get a whole extra deed signed up to vary the existing deed, then you might consider an agreement being more appropriate in those circumstances. And so, as I've alluded to a couple of times, we're obviously in the middle of a pandemic. And so Paula's going to talk through some practical tips that have changed recently.
Yes, thanks, Leighton. So everything Leighton said about deeds and agreements, we probably need to put on ice until the 31st of December. So like a lot of other aspects of our lives, things are changing, and COVID is certainly teaching us, particularly as lawyers and as people, to be adaptable. So the Queensland Government has passed a package of regulations that will allow some property documents, such as deeds, mortgages, powers of attorney, to be signed electronically, and also to allow witnessing by audio-visual links. So that legislation is the Justice legislation, COVID-19 Emergency Response, the Documents and Oaths Regulation 2020. That is in effect now and will end on the 31st of December this year. So it's certainly going with the times and recognising the difficulties that people will have getting documents executed and witnessed at the moment, with restrictions in place in relation to contact, people quarantining, those type of things. So when we walk through, there's a few little different changes depending on the document. So we'll start with deeds. So deeds temporarily will actually start to fall into line with the execution requirements of an agreement for the most part. So deeds can at the moment be signed electronically. So you can put an electronic signature on, such as DocuSign or similar, or you can sign a copy, scan it and send it off. The requirement for execution on paper or parchment has been removed, so you don't need a wet ink signature. They have quite helpfully moved the requirement for deeds to be witnessed, so you don't need to have a witness for a deed at the moment. And deeds can now be signed in counterpart. It's not necessary if you've got two company directors signing off on a deed. They don't need to sign the same counterpart. They can sign separate counterparts. But the one thing to note, it still needs to be delivered in accordance with Section 47 of the Property Law Act, which is you must hold the intention for it to be legally binding upon signing and sending. So quite at the moment, deeds are looking a little bit different than what we're used to, but it's actually proves quite helpful when we've got people working from home and the like, and moving with the times at the moment. Similarly, there's been some changes in how powers of attorney can be granted. So there's no need for a power of attorney signed by a corporation to be witnessed anymore. There is still a need for an individual giving a power of attorney to have a witness, but that witnessing can be done by audio-visual link, which I'll talk about in detail in a second. Powers of attorney can be signed electronically now, so you can pop your DocuSign on or sign and scan a copy. And similarly, it can be signed in counterparts, so you can have two directors sign separate counterparts. Just keep in mind with powers of attorney that there are some additional certification requirements if you want to lodge that. So be mindful that Signing the power of attorney, if you need to lodge it for land titles, there are going to be some extra hurdles that you need to go through to certify that. There's similar amendments that will be made for affidavits and staff decks. I won't go into them at the moment. They don't tend to arise very often in property transactions. Now, the AV witnessing requirements. So the amendments only apply where the witnessing is required to be witnessed, where the document's required to be witnessed by a special witness. And what we mean by that is where a document's required to be witnessed by a lawyer, a commissioner for declarations, notary public, or those type of witnesses. So how do you go about doing an audio visual link and discharge your obligations? So it's by a video call. So the witness will need to observe the signatory actually sign the document. If you're witnessing these types of documents, you do have some requirements that you need to meet. So you need to be satisfied by what you see and what you hear, that the signatory is actually signing the document in front of you on video. It's got to be real time, so you can't actually record a video and then send it by email. It's got to be real time, and I think we're all pretty used to some of the real time technology. We use Blue Jeans, Teams, Zoom, FaceTime. Any of those real time requirements will meet the test. And you must watch every page being signed, and you must be satisfied that the document's not being signed under coercion. So have a look around the room, make sure that there's, understand who else might be in the room, what else might be said. Ask questions if you need to be able to establish that they're not signing under coercion. You also, as a witness, have a requirement to make sure that you verify the identity of the signatory and that the name on the actual document matches the person that you're seeing. So this is in addition to any VOI requirements that you might have elsewhere. So make sure you do, if it's someone not known to you, check their ID and also check the document. Quite helpfully, it might be a good idea to ask for a copy of the document that you're witnessing before time, so you've got that in front of you as well. Once they have signed the document while you've been watching, they will need to send you the document. They can do that by sending you the original, or they can do that by sending you a scanned copy. And then you need to sit down and sign the witnessing panels of that document, either on the scanned or original. There's other witnesses. It's your requirement as first witness to send it to the other witnesses. And if there are no other witnesses, you send it back to the relevant person. So there is a requirement to meet there. So if you are a special witness, please be mindful that you do have some extra obligations. Please note that land titles documents still need to be originally signed. There has been some leniency from the titles office in relation to witnessing if a person is in quarantine or isolation. So if the person is in quarantine or isolation, the titles office will accept audiovisual witnessing requirements. And the titles office preference is that the original document that's signed by the signatory get mailed to the witness for the witness to actually sign the original. But if this is not possible under extenuating circumstances, the witness can actually wet ink sign a copy, and it's that witness wet ink that needs to be lodged with the titles office. And don't forget the VOI requirements. So in whole, COVID is teaching us to be adaptable. It is teaching us to use this new technology, and quite helpfully the requirements have been relaxed.
Thanks, Paula. And so it clearly is a new world. And like we've said, documentation is more critical than ever in these hard times and hard times moving into the future. Planning for worst case scenario is, I think, going to be the new norm. And although nobody could have predicted a worldwide pandemic everybody can have occupancy documents that are accurate, fit for purpose, legally binding and enforceable. So we hope that you got something meaningful out of today.
We've got time for questions. So if you click on the typing, we've got about 4 or 5 minutes left. I do have one question. I've got a couple of questions that come through. First of all, I'll read this out. So given that there's ordinarily quite a bit of expense associated with building signage licences, why are licences used instead of leases for building signage, particularly when the signage licence runs concurrently with a lease? That is a very good question. In relation to signage licences, they tend to be in the form of licences probably for 2 reasons. The first one is generally landlords won't want to give exclusive occupation rights outside their building, particularly if we're talking about signage on top of buildings and things like that. So licences probably do actually suit the practicalities of signage better than leases. The other issue is probably more of a commercial issue, is that landlords can be a little bit choosy about who they give signage and naming rights to. So if you think of a commercial office building, if Clayton Hughes were to own the building that we're in, we're probably quite happy to have, some name on top of our building. Might not be so happy to have a name of another law firm on top of our building. So because of the nature of signage, sometimes they can be seen as personal rights. So it is the fact that signage licences are often granted for those couple of reasons instead of having leased areas. I hope that answers that question. If you've got any more questions, we've got about a minute to go through. I do have another question up here, but it is related to the COVID rental relief regime. So I might actually answer that one offline for who sent that. So I'll give you another little bit. If you've got a question about leases, licenses, deeds, agreements, how to witness in the current climate, please type them through. Otherwise, I'll give it another 30 seconds and then we'll call it a event. So we hope you've enjoyed the format. It's certainly been a bit different not having you all in the room. Kind of missing seeing all of your faces, and certainly I hope you didn't miss the catering too much. It looks like
we might close it down and respond to any questions that have come through separately after the...
Fantastic. If you think of anything afterwards, please feel free to keep popping it on the chat. We will have a look at your questions and we'll pop all the questions and answers down in the information that we send to you afterwards. You'll also get a recording and a copy of the slides. If you do think of anything else or need assistance with anything, please reach out where you can be contacted anytime. Well, thank you very much for all your time. We hope you've learned something and I hope you can go away and check all your leases and licenses and deeds in agreement. Make sure you don't get caught in a predicament.
Thank you.
Thank you.